guys, I am Florian Hernandez and welcome to my first ever discussion. Now, we are going to discuss about the administration and teaching of intellectual property. But before that, we will first define what is intellectual property and the two branches under it. Intellectual property means the legal rights which result from intellectual activity in the industrial, scientific, literary, and artistic fields. Countries have laws to protect intellectual property for two main reasons. One is to give statutory expression to the moral and economic rights of creators in their creation and the rights of the public to access to their creations. The second is to promote, as a deliberate act of government policy, creativity, and the dissemination and application of its results, and to encourage fair trading which would contribute to economic and social development. Generally speaking, intellectual property law aims at safeguarding creators and other producers of intellectual goods and services by granting them certain time-limited rights to control the use made of their productions. Those rights do not apply to the physical object in which the creation may be embodied, but instead to the intellectual creation. What is industrial property? Industrial property takes a range of forms. This includes patent for invention, industrial design, trademark, service mark, layout design of integrated circuits, commercial names and designations, geographical indications, and protection against unfair competition. Aspects of industrial property is less clearly defined. The objective includes conveying information. What about the other branch of intellectual property, which is the copyright? Copyright relates to literary and artistic creations. It is referred to as the author's right. It refers to the act of copying an original work which may be done only by the author or with the author's permission. If you do anything creative, like make YouTube videos, paint portraits, or compose your own music, you may want to learn how to copyright your original content. When you create original work, you automatically own the copyright at the moment you write it down or record it. You are not required to do anything else to legally possess copyright. And because we are through about the definition of intellectual property, now we are going to discuss about the three offices under the industrial property. The first office under the Intellectual Property Administration is the Patent Office. The Patent Office in the field of inventions consists tasks in granting and refusing applications, deals with the renewal of patents granted, and have function of disseminating technological information to the general public and deciding on cases of request for compulsory licenses. If you think you have an invention worth patent, then filing for a patent will be your next logical step forward in the road of becoming a patent holder. The patent applicant should disclose the invention for protection. The United States Patent and Trademark Office is the best way to start filing a patent application. But how? In one-stop shop, you can have all the questions answered right here. There are also what we call the patent application processes, where you can think and prepare for the next step ahead of time. But before, you should know that you just can't patent any idea. You need to have a process, a machine, and something that can be manufactured or a composition of work. Your invention should have a purpose and solve a problem in a smaller, faster, and affordable way, and also become an environmental friendly. On the other hand, the Trademark Office handles receiving applications for the registration of trademarks and service marks and deciding whether the registration should be effective or refused. They deal with the request for the renewal of existing registrations, and finally, they are required to give information at the request of any member of the public in its registered of trademarks or service marks that are identical or similar to a sign in respect. It is called a search or search for identical or similar trademarks or service marks. There also exists the Industrial Designs Office. Together with the two is the Industrial Designs Office, wherein inclined in receiving applications for the registration of industrial designs and deciding whether the registration should be effective or refused. They deal with the request for the renewal of existing registration for industrial designs. Industrial designs undergone different processes before it was fully introduced to the public. Designers first have their observations by conducting a research on their design. It should be relevant and have the ability to solve current problem. They combine new design and the traditional one and test for its validity. They use computer software to visualize and have the complete structure of the design. Also, after some processes, they will execute and make it to test for the validity. Also, for the role of intergovernmental cooperative and the collective management organization to the copyright and related rights, here is the role of public authorities on copyrights and related rights varies from country to country. Their role consists of the policy-level function, monitor legislation, and enforcement strategies. They also issue compulsory licenses, and some activities was operated by the collective management organization. Collective management organization was early called collecting societies. They were created to help remove the obstacles on copyright compliance. CMO is an important link between those who create content and those who used it. The primary function of CMO is to acquire, administer, and license copyright and related rights, monetary use, collect licenses fees, and distribute them among their members. Managing content right can be complicated. CMO provides system to administer copyright to keep content uses a more efficient workflow. CMOs represent the works of many different types of creators, from writers, composers, and photographers to publishers, performers, and many others. There is no single type of CMO. They vary from the content and rights they manage and the right holders they represent. Also differ in the types of content uses they address. The most common are the broadcasting, producing sound, and performance. This time, we already knew about the administration under the intellectual property. Now, let's proceed to our next topic, which is the teaching of intellectual property. Students of intellectual property are broad. They came in different professional institutions, which includes intellectual property in their curriculum. The most common are the business-related programs, the law degree, and the specialized postgraduate programs. The quality of intellectual property program depends on interest of the faculty. Their tasks include lectures for professionals. They provide effective and economical way of building comprehensive and high-quality intellectual property program. WIPO, on the other hand, has taken initiatives in order to bring awareness of intellectual property in teaching internationally. There are 4 types of intellectual property courses. The first is the survey course, which gives an overview on intellectual property law. Second, the specialized courses that teaches more specific program under intellectual property. The third is the advanced seminar, which are designed for those who finished specialized courses. And lastly, the practice courses, which focus on the actual step of attorneys to obtain intellectual property rights. In choosing a syllabus will be dictated on the type of courses, and teachers have 2 basic approach in teaching. The first is the case method, and the second is the problem method. So that's it. That's all about the administration and teaching of intellectual property. I hope you liked the video. Thank you.